The people are showing that they've had enough. People are ready for fair and legal elections, or this is what you're going to get. You're going to get more of it.
Remember the co-founder of Cowboys for Trump, who was disqualified by the 14th Amendment for being a county commissioner in New Mexico after he was part of the January 6th insurrection? Well, after the U.S. Supreme Court ruled for Trump in the Colorado case, this guy went up to the court and said, all right, now reinstate me. And the Supreme Court just said, get off our lawn, which is what Donald Trump would probably say if this guy ever showed up in Mar-a-Lago. Let's discuss. I'm Dave Aronberg, State Attorney for Palm Beach County, a.k.a. the Florida Lawman here on the MeidasTouch Network. Thank you for all your likes and your comments. Please keep them coming. And as far as this former county commissioner, this was back in September 2022 when he was first removed from his position by a state court judge named Judge Francis Matthew, who issued a ruling permanently barring Couy Griffin, C-O-U-Y, Couy, or is it Couy? If you know for sure, leave the comment. But I'm going to call him Couy because that sounds like Stewie Griffin from one of my favorite shows. He's a former rodeo star and county commissioner since 2018. But he was barred by the state court judge from holding or running for office because he was convicted in federal court for entering the Capitol grounds. Even though he didn't go inside the building, he was sentenced to 14 days in prison, and he also, as a result, under the 14th Amendment, was disqualified from being in office. According to the New York Times, on January 6, 2021, Mr. Griffin, an avowed denier of the 2020 election results, burst through barricades at the Capitol, accompanied by a videographer, and addressed the crowd with a bullhorn. He did not enter the building. For months before the January 6 riots, Mr. Griffin had attended Stop the Steal rallies and attempted to recruit protesters to head to Washington. Judge Francis J. Matthew of the New Mexico District Court wrote in his decision barring Mr. Griffin from future office. The ruling by Judge Matthew also barred the former county commissioner from serving as a presidential elector. According to the judge, Mr. Griffin aided the insurrection even though he did not personally engage in violence. By joining the mob and trespassing on restricted Capitol grounds, Mr. Griffin contributed to delaying Congress's election certification proceedings. So sorry, not sorry. This guy is now permanently barred from office. So what did he do after the Supreme Court ruling in the Colorado case? Mr. Griffin went to Washington, D.C., and he tried to get reinstated or to get at least the judge's ruling overturned. And the Supreme Court refused to hear the case. Refused to hear it, even though Donald Trump, his idol, was able to prevail 9-0 up there on this matter. When it came to the former county commissioner, he was SOL. That's a technical legal term. And a reason why is because if he had read the ruling, he would know that the Supreme Court's ruling only applied to federal candidates in federal offices, not local county commissioners, not local officials, not state officials. States can still regulate their own elections and use the 14th Amendment to bar people from running or holding office if you participate in an insurrection, even if you didn't go inside the Capitol building that day. So if he had read the opinion, he probably could have saved the hassle of going to D.C., and now he's piping mad. In a recent interview with CNN, Griffin slammed the process that led to his disqualification and also criticized the similar cases against Trump. This whole thing started on a small scale, with them coming after me, with the specific goal of bringing it up to the big stage with Donald Trump. Griffin said, I was the test case. Well, so one thing that Griffin learned is that when it comes to his idol, Donald Trump, what's good for he is not good for thee. There's two separate standards here. And although Trump does seem to be able to get away with things, not so true about his hardcore supporters. Those who stormed the Capitol ended up in jail, not pardoned, even though now he says he's going to pardon them. Others have ended up being ripped off, giving money to the Stop the Steal charity, which was then diverted to other uses, or the We Build a Wall charity scam, led by Steve Bannon, which was diverted to their own pockets, and then Trump pardoned Steve Bannon for ripping off Trump's best supporters. And then others have grown ill or even worse. Those who took hydroxychloroquine instead of treating their COVID properly. Hopefully no one inject themselves with bleach, but you see where I'm going here. Then others have just emasculated themselves, like Senator Lindsey Graham and now most recently Mitch McConnell, who, after repeated Trump attacks on his wife, has endorsed Donald Trump. But that's where we are in our politics. There's an old saying, Democrats fall in love, Republicans fall in line. And that's what we're seeing here. And when it comes to former County Commissioner Griffin, he's just the latest to mess around and find out. I'm using the PG version of that term. But the Supreme Court has kept in place the law that says that if you are a state official or a local official, you can get bounced. The Colorado case does not apply to local government officials. It's for federal candidates. And perhaps if Griffin had read the court's opinion, he would have saved himself a trip to Washington, D.C. Because the Supreme Court denied cert. They denied reviewing the case, and for good reason. The case applied to Trump. It applied to federal officials. And even though it's 9-0, it's a sure loser when a local county commissioner goes and says that my home state is not allowed to enforce the 14th Amendment and associated laws about not being able to run or hold office because they participated in an insurrection, even though they didn't go inside the building. And the person who brought this case is taking a victory lap, and rightly so. According to the New York Times, Citizens for Responsibility and Ethics in Washington, which brought the case against Mr. Griffin, said that the court kept in place the finding that January 6th was an insurrection. Now it is up to the states to fulfill their duty under Section 3 to remove from office anyone who broke their oath by participating in the January 6th insurrection, he said. That is an important point, because one thing the Supreme Court did not do in the Colorado case was to get involved in whether Trump participated in an insurrection. So they let stand the lower court's rulings. And the lower court rulings in the Colorado case found that Trump engaged in insurrection. So that is undisturbed by the U.S. Supreme Court's decision, even though they overturned the finding in the ultimate ruling in the case. And as here, the Supreme Court did not touch the fact that a local judge found that this county commissioner engaged in insurrection. So there's nothing in the law that says these January 6th rioters are not insurrectionists. In fact, the law seems to suggest the contrary, especially as the Supreme Court refused to touch the lower court's ruling on that. So here we are in the year 2024, which I really believe is the year of accountability. Don't get demoralized. Don't lose hope, Midas Mighty, because accountability is coming, and former County Commissioner Couy Griffin, and I stress former, is just the latest to find out. And he'll always be a former, because his case is now over. I'm Dave Aronberg, aka the Florida Lawman. If you like this video, please like it, and I'll see you next time.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.